So, hello everyone. Good evening. I hope you all are doing well. This side, I am Bhumika Brahmgat from Team Legal Vidya. So, today webinar is about access to the justice and the challenges and the innovation in the India and South Africa. So before briefing about the webinar and the speaker, I will definitely like to introduce what Legal Vidya is. So Legal Vidya is an online education tech platform where we provide a numbers of the opportunity out there for the law students and the legal profession in a various form, where we provide internship, we conduct the webinars, workshop, relevant courses, and other opportunity out there. You can definitely look on our website and other social media handles for it. And also, now I will brief you about what exactly today's webinar is about. So today's webinar will be explore the structure, economic, and the legal challenges that hinder the access to the justice in the India and the South Africa, while which also highlight the legal framework, institutional reforms, community-based solution that are emerging in the both the countries. By comparing this jurisdiction, the session will aim to identify the pattern, different and the collaborative learning opportunity where to assess the justice system which will be equitable. Also, you will able to learn inside the role of the legal aid, public interest litigation, digital court, pro bono, in promoting the justice for the marginalized community. The discussion will also touch upon the impact of the technology, legal education, judicial reform in improving the accountability and accessibility. So do not miss out this opportunity to engage in the comparative legal dialogue and understand how we can make justice more inclusive and effective. Now, you might think who the speaker is, the expert is, right? The expert is Lisa V. Thomas, advocate, ma'am. She is a seasonal legal professional with experience in both the criminal defense and legal assistance, based in Durham, South Africa. She holds an LLB degree from the University of KwaZulu Natal, which is South Africa based. After completing her pupillage, Lisa ma'am was admissible as an advocate barrister in 2008, making the beginning of the career deeply rooted in the both private and the public law practice. In the here, Lisa ma'am has focused her legal expertise on the alternate dispute resolution, particularly mediation. Our commitment to empowering the next generation of legal profession, which lead to the foundation of SUAME, which is SA University Mediation Enthusiastic, a mentorship which is designed to cultivate a passion for the mediation among the university students. Lisa ma'am is also the driving force behind the Legal Profession Empowerment Hub, which provide the support to the law students from their first year to the practical vocational training and beyond to the practical career. Also, BAM is actively engaged, like she's a legal educator, career mentor. She also widely through the LinkedIn teaching posts her legal academic and career coaching platform. She's actively posting on her LinkedIn. I also see the valuable content out there for young lawyer and legal profession. She is also a presenter and lecturer with UCT Law Work Professional Development Project, where she contribute to the continuous learning of the legal profession, guidance by the ethics. Also, ma'am is passionate about the advocate for the humanity, ethics, and the accessibility. Legal education, making a valuable mentor and lifelong resource for the aspiring lawyers across the South Africa. So we are very pleased to have the ma'am with us as a speaker today. We are very welcoming you, ma'am. Also, the few instruction I will like to give before handing over the session. Please, in between, do not interrupt by unmuting yourself. Feedback forms will be provided to you. To you all, you have to fill it for the certificate purpose. Also, this session is being recorded. Recording will be also provided to you. Your doubt and the question will be taken at the end of the session. So please maintain the decorum of the class. Over to you, ma'am. Hello, I was audible, right, everyone?
Yes, ma'am.
Okay, thank you. Over to you, ma'am, Lisa, ma'am. We are not able to, ma'am, hear you. Sorry. I think there is some technical glitch. We just have to wait for 2 to 3 minutes. Please. No, I have not unmuted her. No, I have not. Just a minute, I will check. Yes, I have not unmuted. Just a minute, let's get back to it. Please maintain for the 2 to 3 minutes. Sorry for the inconvenience. Hello, participants. We just have to wait for 2 to 3 minutes. I think there is a something technical problem over there. So please maintain the patience and thank you everyone for the patience.
Good evening, everyone. The speaker is joining again. There is some technical glitches in the ma'am speaker. The speaker is joining again. Thank you.
Yes, ma'am, we can start over the session.
Hi, I am audible.
Huh.
Yes, ma'am. Good evening,
You're
ma'am.
audible.
Okay, I'm so sorry. My mic wasn't picking up for some reason. Um, Thank you so much to the Legal Vidhiya team. I'm very Humbled by your invitation. Obviously, I've met you, not connected with you guys before, so I needed to know a little bit more, but I'm very, very impressed by the mission and the aims of the organization. So, and it fit in with what Bhumika said I'm involved in, so it's very much in alignment. So therefore, I accepted the invitation. So without any further delay, I'm gonna get going. So today, I'm gonna be talking on access to justice, issues, challenges, and innovations in India and South Africa. Okay, so good evening, everyone. Officially, it's great to be here to talk about a topic that is fundamental to a just society, which is access to justice, right? We're going to explore this idea through the lenses of two countries, as I said, India and my home country, South Africa, to see the challenges that they face, and of course, the inspiring innovations that each one has developed. Right? So, firstly, why access to justice matters? So let's take a moment to consider some questions. Right? I'm sure some of you have come up with similar questions, such as how does a low-income family challenge an unfair eviction? Or how can an illiterate person defend themselves in court? Or how can ordinary people hold powerful corporations or governments accountable? Okay, if people can't afford lawyers, if the legal system is too slow, if they don't even know their rights, then justice is nothing more than just an abstract concept, and it only exists on paper, and it's not a reality for them, right? So, what are the core principles of this thing we call access to justice? So, before we dive into the specifics, it's essential to understand what we mean when we talk about access to justice. It's not simply about being able to go to court, right? It's about a set of fundamental principles that ensure that the legal system works for everyone. So the first core principle of access to justice is equality. So the law must apply equally to everyone, regardless of their social status, their income, their gender, or their background. Their wealth should not determine their ability to seek a legal remedy. A second core principle of access to justice is affordability. So the cost of legal services, including court fees and lawyers' fees, should not be a barrier to seeking justice. Legal aid programs, pro bono services, and low-cost alternatives are essential to meeting this affordability principle. Right? The third core principle of access to justice is timeliness. Justice delayed is justice denied. I'm sure you've heard that saying often. The legal system must be efficient, and cases should be resolved in a reasonable time frame to prevent undue hardship and also to preserve trust in the judiciary. Um, a fourth principle is legal empowerment. So people must be aware of their rights and have the knowledge and the tools to navigate the legal system. This includes legal literacy and access to basic legal information. And the last core principle of access to justice is accessibility. The justice system, including courts and legal services, must be physically and culturally accessible. This means adapting to different languages, using technology to reach rural areas, and having forums that are less intimidating than formal contents. These principles serve as the benchmark against which we can measure the success of any justice system. Okay, so firstly, I'm going to talk about India in terms of its challenges and innovation. So we all know that India's sheer size and diversity make access to justice particularly challenging, right? It's far, far bigger than South Africa. Court cases can drag on for years, sometimes decades, and of course, litigation is prohibitively expensive for the poor, right? Many rural communities also lack basic legal awareness, and the legal aid system, while a constitutional right, struggles with underfunding and a shortage of quality lawyers. Um, Despite these hurdles, India has developed remarkable solutions, and I think South Africa can learn from some of these solutions. The people's thoughts, okay, these are quick and informal forums where disputes are settled amicably and cheaply, right? Mediation centers are now common in family and civil cases, helping to reduce backlogs. Telelaw uses video conferencing to connect citizens in remote areas with urban lawyers. And the Nyaya Bandhu is a platform that links volunteer lawyers with people who need pro bono assistance, right? So these are quite remarkable innovations that India has developed, and I don't think South Africa has that many options as we will see further on in the talk, right? So now I'm going to talk about South Africa in terms of its challenges and innovations. South Africa, with one of the world's most progressive constitutions, faces its own set of challenges. The legacy of apartheid, right, very similar to the civil rights movement in America, where blacks and whites were separated, has led deep inequalities, and legal fees are so high that only the wealthy can afford rate litigation. Courts are often under-resourced and backlogged. And if I can give a very real example about the backlog, when we're looking for trial dates, we're often getting dates like 6, 7 years, 5, 6, 7 years from now. Okay, so it's really, really backlogged. Although legal aid in South Africa does tremendous work, and I worked for legal aid at one point, that's where my criminal defense experience comes from. Its budget is stretched very, very thin, with most resources dedicated to criminal cases. So the civil cases actually get sidelined, right? But we also found ways here to address creative ways to address these issues. So, firstly, legal aid is still an option, even though it has its limitations, because it's a nationwide network that provides free legal help. Community advice officers, these are grassroots hubs run by paralegals, right, serving as a first point of contact for many people. We've now introduced mediation, mandatory mediation or court compelled mediation via our high court rules. So here we have high courts and we have magistrates courts. Those are the two basic divisions. And so we have now introduced rules, a rule in the high court that mandates mediation for civil matters before any trial date is sought, right? And of course, this encourages dialogue and settlement early in the civil litigation process. We also have, to a limited extent, restorative justice mediation. So this is used especially for young offenders, right, in the system, the criminal justice system, focusing on healing and reconciliation rather than putting them in jail. Okay. We also have digital court processes such as our case lines system. When I was coming up, that didn't exist. So it's a fairly recent development where you can have digital platforms, electronic filing, video testimony, basically modernizing our judicial process, but that's taking some time to actually get going. Okay, so I think we wouldn't be sugarcoating it a lot if we just spoke about the innovations and we didn't talk about the shortcomings of these innovations, right? So as much as we are trying in India and in South Africa, but we have to be mindful of how efficient these options actually are, whether they're actually working for the people. So in terms of the people's courts there in India, while it's effective at clearing backlogs, these courts have a few key limitations, right? Such as decisions are based on compromise, not legal principles, and the outcomes aren't subject to appeal. And this can create a situation where parties, particularly the weaker ones, can feel pressure to accept an unfair settlement just to avoid the lengthy formal court process. Additionally, the voluntary nature of participation means that if one party refuses to cooperate, the case still has to go to a conventional court, defeating the purpose of the People's Court. Okay? The Telelaw and Nyaya Bandhu, these platforms are fantastic for bridging geographical gaps, okay, but they face a significant hurdle in terms of execution. The effectiveness of these services depends heavily on a stable internet connection and digital literacy, which are often lacking in the rural and the remote areas they aim to serve. Furthermore, the number of lawyers volunteering for pro bono work can be limited, leading to long waiting times and a potential mismatch between the legal expertise needed and the lawyers available. The mediation centers. So in terms of that, the success of mediation relies on the willingness of both parties to find a middle ground. And in cases where there's a significant power imbalance, such as a poor individual against a large commercial corporation, the weaker party may not feel empowered to negotiate effectively. Moreover, while a mediator's role is to facilitate the process, they do not have the power to compel a resolution, meaning that the process can fail, resulting in further delays and costs when the case returns to the formal court system. Okay, so South Africa's shortcomings, the shortcomings of our innovations, right? In terms of legal aid, I've already alluded to one of those, that the criminal cases get the priority of the budget. So although it's a critical lifeline for many, legal aid is severely underfunded and overburdened, right? Because the majority, from my experience, the majority of the criminals or the accused people, or once they get charged, they can't afford legal services. So the demand, the strain on the system is immense, right? Its budget, legal aid budget is not nearly enough to meet the demand for its services, and it must prioritize severe criminal cases over other legal issues like civil matters, evictions, or consumer disputes. Yeah, this leaves a significant gap in legal assistance for many civil matters. The high caseloads can also lead to an overworked staff, potentially affecting the quality of legal representation provided. Okay? In terms of our community advice officers, these are vital for being on the ground and accessible to people, but the efficiency can be inconsistent and often run by volunteer paralegals who, while dedicated, lack the formal legal training of a lawyer. This limits the complexity of the cases that they can handle. Additionally, these centers rely on donations and grants, making their funding unreliable and their long-term existence uncertain, which can lead to closures and disruptions in service for the communities they serve. In terms of our restorative justice mediation for juvenile offenders, this innovation is highly effective for its intended purpose of healing and reconciliation, but it's not a one-size-fits-all solution. It is most suitable for less severe crimes and requires the consent and active participation of both the victim and the offender. In cases of serious offenses, particularly those with a history of violence or abuse, right, such as like repeat offenders, like repeat juvenile offenders, restorative justice may not be appropriate or safe for the victims in the process. Okay, the digital courts, the case lines software that we have. So while it modernizes our judicial process here in South Africa, these technologies create a new form of digital divide. The access to digital courts requires reliable internet, a stable power supply, and proficiency with technology. And again, like in India, for many with rural or low-income communities, these necessities aren't guaranteed, meaning the very people who need more efficient access to justice are often the ones that are excluded from these digital solutions. So hopefully, if you've been listening critically, you would have identified some common challenges, right? And I also want to talk a bit about what are the roots of these common challenges of access to justice that India and South Africa face, right? So while our specific histories do differ, India and South Africa share fundamental barriers to justice. These common challenges arise from similar historical and socio-economic contexts. Number one, the high cost of litigation, right? So in both countries, legal fees are a significant challenge. This is a legacy of colonial legal systems, which were designed to serve the elite and the interests of the state and not the general populace. Over time, these systems became formalized and expensive, making them inaccessible to the poor and the marginalized. Another common challenge that our countries face are case backlogs and delays, right? All judicial systems are notoriously slow. This is a direct consequence of a combination of factors, right? The first factor here are overburdened courts. So with India's massive population and historical socioeconomic inequalities, in our case, um, it leads to a massive volume of cases, far exceeding the capacity of the courts, right? And of course, the fact that we have adversarial systems of justice. Under-resourcing is another factor. So both governments struggle to allocate sufficient funding to the judiciary, resulting in too few judges, clerks, and court facilities, and also the maintenance of those facilities, right? Another common challenge is the lack of legal awareness. Okay? Many citizens, particularly in low-income and rural areas, do not know their rights or how to navigate the legal system. So this is tied to historical disenfranchisement, right? And low literacy rates, where education about legal rights was never a priority for the masses. And this is where people can be taken advantage of by lawyers that are just out to make money, right? If they don't know their rights, then they may get taken advantage of and maybe get their matter put through the system when it doesn't have to go through the legal system. It could just be resolved sort of by mediation or something similar. A common challenge is ineffective legal aid, right? So while both countries have established legal aid programs, they are often insufficient and they suffer from underfunding and a lack of qualified lawyers willing to undertake this work, leaving many without the quality representation that we need. Now, these shared challenges are not mere coincidences. They are rooted in a shared past of colonialism and the ongoing struggle to adapt a formal Western legal system to the needs of their diverse, developing, and highly unequal societies. All right. So, as mentioned in my introduction by Bhumika, my passion is mediation, right? And all things to do with ADR, alternative dispute resolution. So, the emergence of alternative dispute resolution in both India and South Africa is a direct response to the systemic failings of the formal legal system. ADR mechanisms like mediation and conciliation aren't just a convenient alternative anymore. They are becoming an essential component of the justice system. And I'm sure you've heard the common advantages of ADR, right? It lies in several areas. Number one is cost effectiveness. So ADR processes significantly reduce legal costs. Unlike lengthy litigation that requires extensive legal fees, expert witness costs, and court fees, ADR offers a more affordable pathway to resolution, making justice accessible to those who are otherwise priced out of the system. Okay, the second advantage is that it's time saving. So ADR mechanisms are designed for speed. In India, obviously the people's courts have been successful in clearing millions of pending cases in a single year. A feat unimaginable in a conventional courtroom or conventional legal system. Similarly, our Rule 41 that I mentioned, 41 capital A, mediation process aims to resolve civil matters much faster, preventing them from adding to the court's growing backlog. A third advantage is flexibility and control. The ADR empowers the parties involved. Instead of a judge imposing a decision, mediation allows individuals to participate directly in finding a solution that works for them. This creates a sense of ownership over the outcome and often leads to more sustainable agreements that preserve relationships, which is particularly vital in family, community, and even in commercial disputes. So the shift in ADR from a more purely adversarial model to a more collaborative one is not just a procedural change, right? It's a fundamental change in philosophy that places people and not legal formalities rather at the center of the justice process. Right? So now I want to talk about shared innovations, right? So the stuff that we've been getting right in both our countries, and let's talk about a global blueprint for justice. So the solutions developed in India and South Africa provide a powerful blueprint for other nations facing similar issues. So, and despite geographical distance, our innovative approaches do share key characteristics. So there are some things that we are doing right together, right? As I just mentioned, ADR mechanisms. So both countries have successfully moved away or are moving away from purely adversarial court battles. The People's Court began an hour reliance on Rule 41A for mediation, proved that resolving disputes through dialogue and compromise is not only faster and cheaper, but is more sustainable. Okay, both our nations empower grassroots organizations. So both nations recognize that justice must be brought to the people, not the other way around. So India's telelaw facility connects to rural citizens with lawyers via tech, right? And at the same time, South Africa's community advice offices and legal aid clinics use on-the-ground paralegals to serve as a vital first point of contact for the poor who need legal services. And this decentralized model is essential for reaching remote or marginalized communities. Thirdly, both our countries are leveraging technology. So technology is a key enabler, right? India's Telelaw and the Nyaya Bandhu platforms use digital tools to connect clients with lawyers, while South Africa's Case Lines system modernizes court procedures to reduce physical backlogs. And these innovations show that technology can bridge the gap between legal knowledge and those who need it the most, even with its shortcomings, right? Both our countries share a focus on legal education and pro bono services. So in both countries, university law clinics play a dual role. They provide invaluable hands-on training for students while offering free legal advice to poor clients. This model not only expands access to justice, but also instills a public service ethos in the next generation of legal professionals. And just by way of example, when I was at university studying for my LLB, in my final year, I chose clinical law because I wanted to see. At that stage, I needed to know how my theory and my academic knowledge was going to help the people on the ground. And so I was able to work with a client, a poor client that came in from the outside, and I got a first-hand, not a very nice impression, but a first-hand impression of how the law is applied in the real world, right? So these shared innovations demonstrate a universal shift in thinking about justice. The focus is moving from a rigid court-centric model to a flexible, people-centric one. And as we wrap up, I want to talk about law as a service, a profession, as a service profession and not a career. Okay, I want to challenge your thinking in this regard. So let's reflect on what this means for you, right? So the law is often seen as a commercial career, a path to prestige and financial success. And I don't know about the Indian culture there, but here in South Africa, um, you are sort of pressured to choose either being an accountant or being a lawyer or being a doctor or being a teacher. There's a big five that we have to choose from because those are seen as prestigious careers, and the family takes great delight in um, uh, boasting that their child or their grandchild is studying law or medicine, right? Um, but I want you to see that the innovation we discussed today shows that the law's true power lies in its identity as a service profession. Okay, so the law is not just about head knowledge, precedents, and procedures. It's a living tool to number one, protect the vulnerable, number two, empower the marginalized, number three, challenge injustice, and number four, to build fairer societies. So basically, the people on the ground don't need abstract legal theory. So, for example, if there's a widow that's being helped in the widow
मुलजिम
needs help,
साहब कहना शुरू करो
if,
कोर्टरूम का
if the
ड्रामा
widow
घर के
needs
ड्राइंग
help
रूम में रिहर्स
in
करो
the people's court, she doesn't care about how much knowledge you have as a lawyer. Okay, she just needs help. She needs a problem to be solved. Same thing as a farmer here in South Africa in the rural areas who had his cattle stolen. He doesn't care about how much you know or what marks you got at university. He just needs to get his cattle back. Right? So people, everyday ordinary people need lawyers who can translate knowledge into action, who can take the law out of the books and into people's lives. And this is the central challenge and opportunity for you as future legal professionals. The real measure of your success will not be the size of your firm, if you start a law firm, or your salary, but the positive impact that you have on your community. It's about using your skills to serve, to make a tangible difference in the lives of those who need it most, right? So what are some practical steps for you going forward, right? How can you facilitate access to justice as an individual, right? So as future legal professionals, your role in advancing access to justice is pivotal. You are the next generation. The change starts with you, right? You can't wait for the whole huge system to change in one go, right? We have to start being the change. So firstly, you can become proficient in ADR mechanisms, right? Go beyond traditional litigation. Learn to be an effective mediator, a skilled negotiator, and a compassionate arbitrator. The future of justice relies on lawyers who can resolve disputes efficiently and amicably, not just through courtroom battles. And secondly, you can volunteer at clinics. So the practical experience you obtain at legal aid clinics is invaluable. You'll not only be providing free legal advice to communities, but also learn to apply legal theory in real world contexts, often using ADR to achieve swift resolution. You can also advocate for reforms. So use your voice to champion legal reforms that support non-litigious options or other options that can create access to justice, right? Raise awareness about benefits of other mechanisms, advocate for policies that will make it a reality and more accessible and enforceable, right? Think innovatively. So how can mobile apps, artificial intelligence, or digital platforms be used to simplify dispute resolution? Okay. The next generation of legal innovation won't just be about faster filing papers or whatever. It will be about creating new pathways for justice that are affordable and user friendly. And in closing, I want to leave you with this. Access to justice is about fairness and equality. It's about using the law as a force for good, and the revolution of access to justice is unfinished. Okay, but perhaps it's your generation that will finish it. Thank you very much.
Yes, anyone is having any question, you may ask the expert. She's right away here. She has explained all the points which were described in the webinar introduction. So you can definitely ask me, ma'am, whatever is in your mind, one by one, please. We are not having any question, participants. All thing is been clear in your head. Is that so?
Please talk back to
Yes,
me. I love talking. I don't like being the star of the show. Please, I
yes.
welcome your questions or even your critique. That's also welcome. I
Yes, in the
think
chat box, the
yeah.
question is coming up, ma'am, that do you see a technology like AI tools or the online dispute resolution playing a long-term role in improving the access to the justice in the country like India and in South Africa? Yukta is asking this question now.
Thank you for your question. Definitely. I think the pandemic COVID-19 has highlighted the ODR process, so the online dispute resolution, where people, you can mediate online, you can arbitrate online. So that definitely, I think it's grown a lot since the pandemic. So it definitely it's definitely a viable option. Obviously, the challenge, like I pointed out, will be how do we get it? How do we make it accessible? How do we make internet cheap? For example, in the rural areas, how do we get them a nice connection, community, maybe a community shared connection for them to all join, connect to the internet and be able to use the platform. So ODR is definitely a viable option. What you guys need to come up with now is um, how do we get rid of those shortcomings and make it truly accessible so that those that actually need it in those areas, not in the rural areas, can actually access it. So we can have sponsored internet or something like that. That might be an idea.
Yes. I hope Yukta, your question has been answered by the ma'am. Yes, thank you. She's saying thank you, ma'am. Yes, anyone
Welcome.
else would like to? You can unmute yourself and ask the question directly also. So it will be also two-way communication to the ma'am also, and ma'am will be like, okay, there are someone who can, we are able to visible it, right?
Yeah, please talk back to me.
Yes, anyone would like to ask anything? From the topic itself, that alternate dispute resolution, which is a very strong mechanism, right, in a present time, is going out around all the countries, especially the country like India, South Africa, and London and Singapore. Like, there are many, right? So you should ask something which will be benefited to you to know from the ma'am experience, right? The question like this, that how the mechanism work in the South Africa, you should ask like, I will definitely on of your behalf, I will like to ask that the sitting is similar that the international arbitration hubs are having, ma'am, or it will be the particular pattern for the domestic dispute, I am asking, ma'am.
I'm not understanding your question.
Ma'am, I'm asking that for the domestic dispute over the any matter, if it is they are opting for the arbitration, so how
Yeah.
the procedure is followed in the South Africa? I just want to know on it, if you can brief it.
Okay, so here, it's a very limited option still. It's mainly used for commercial matters, although there have been some discussions about using it for divorce. So arbitration, unfortunately, I didn't prepare. I'm mainly in the mediation space, but South Africa has also become an international seat for arbitrations. We've made some significant development. It's mainly used in commercial disputes. So if it's part of a contractual, it is a contractual dispute and there's an arbitration clause, then of course parties have to use that first instead of going to court. So I unfortunately I can't speak off the top of my head and I don't want to say anything incorrect, but that's it's not widely used in terms of, I would say, mediation and conciliation are more widely used, and mainly in family matters and labor law matters that they use. Actually, arbitration also is limited. Unfortunately, it's limited both to labor law and commercial law in South Africa. So we haven't really taken it out of that space. So we have what's known as the CCMA here, which is the Commission for Conciliation, Mediation, and Arbitration. So that's where the majority of the labor disputes go. And so conciliation, mediation, arbitration is applied to labor law disputes. And like I said, just general contractual matters where arbitration and arbitration clause, that so arbitration will be involved in those matters. Yeah, but I think in terms of overall popularity, mediation is what our courts have been pushing.
Thank you so much, ma'am, for answering it. One last question is that you highlighted server shortcoming in the access to the justice in the both India and South Africa. Which of this do you think is the most urgent to address? Yukta is asking, ma'am.
Okay, let me go back. Um, which is most urgent? Gosh, they're all, they all. Um, I think education. Um, because it just saves people. It just saves time if somebody can find out about their rights without having to pay a lawyer to find out. Because often that's where they come, if their first point of contact with the legal system is the office of the lawyer. And so if we can reach them and let them know what their options are, because I think we can do that without charging people. It's an unpopular opinion, at least here, that you can actually let people know what their options are and you don't have to charge them for it. So people often feel limited in that, oh, like I need to have a certain amount of money. So if I don't have that amount of money to go to the lawyer's office, then I can't access. I don't know. I won't know what to do. And so I think just being on the ground and educating people so that they know, okay, this is something that I don't need to go to court for, or this is something that I can do via mediation. I think some of that kind of advice can be given free of charge. And then it's the actual work perhaps that we charge for. So I think we put a lot of emphasis on giving advice, on charging for the advice that we give, as opposed to charging for the work that we do as lawyers. So I think we should focus on educating people for free about their legal rights and when it comes to the actual work, that's the only thing that we should be charging them for. So definitely um, improving legal education, uh, not just in colleges or at universities, but the man on the streets. He has to know what he can do if his rights are being trampled on, for example, by his employer. And he must have sufficient faith also in the system to say that if I want to enforce those rights, that I'm going to be successful. So that's the other hurdle that we have to face. We give them the knowledge about, okay, these are your options, but then they might say, but the system is so slow. I have these rights, but I don't actually feel confident in the system to enforce them. So I'm just going to let my rights be trampled. It's okay. So there's the other side to it as well.
Yes, definitely. Such rights are our fundamental right. We also having the right to education, also the equality in the employment, and those all things. Very true, ma'am. You are saying. So thank you so much, ma'am, for such a valuable session on the mediation, which is very important to have in both the country and in every country. Mostly, I think so. It will be the good part. Uh, Other than opting for the litigation or lengthy process, it will be definitely helpful for the students who have joined the legal profession, who have joined the session from your expertise area. Also, ma'am is having the great content on the LinkedIn. You can definitely visit her profile. She every day posts some very, very, very interesting fact about the baby lawyers, which I definitely read out there. So you can also opt for it, which are very useful and very logical in a sense of the practicality, right? So you can definitely visit that also. And thank you so much, ma'am, to have such a wonderful session with the Legal Vidya. Thank you so much, ma'am, for joining out there. And all the
Thank you.
participants also for the joining out there. They all are thanking you, ma'am, in the chat box. Thank you.
Thank you for attending. I didn't expect to have I think it's the biggest audience that I've had, so it wasn't that easy to present. But thank you for showing up, and you're ultimately showing up for yourself. It's for your benefit, and please connect with me on LinkedIn. Like Bhumika said, it's Lisa, Lisa Valine, V for Vicky, Alene. Thomas. And there's only one of me on LinkedIn, so you'll be able to find it. Please connect with me. I love the conversations and the connections after all these events. And of course, if you connect with me, you can see all of my posts that I do for my baby lawyers, which also includes ADR team. So thank you again to Legal Vidya. It was a privilege, and hope to keep the connection and maintain the relationship going forward. Thank you so much.
Definitely. Definitely. Definitely.
Ma'am,
I will be, if you're not
ma'am,
getting, I will be sharing.
ma'am, can I get your Insta ID, ma'am?
They are asking for your Insta ID. If you are having,
My
ma'am,
Instagram. Oh, I didn't hear that properly. What's my Instagram? Oh, it's the same thing. It's so my LinkedIn is the one that I maintain the best. But I do have a YouTube channel and an Instagram profile. It's Your Friendly Law Mom, all one word, right? So it's Your Friendly Law Mom, LAWMOM. So search for Your Friendly Law Mom on Instagram, and my YouTube channel also is also of the same name.
I hope all have noted down. If you are not, I will be sharing. Do not worry, everyone. Anything else you want to ask? Last chance. Okay, okay. So thank you, ma'am, again for joining out. We will definitely have the
Ma'am,
relation and
Bhumika,
definitely.
ma'am, kindly provide me just a link of her Instagram, please, ma'am.
Okay, I will be sharing with you all in the along with your certificate. I will be sharing you all. Do not worry. Thank you, ma'am.
Okay, thank you. Bye, everyone.